All right, everybody, welcome back. Attorney Steve Vondran. We got some breaking IP news for you, so hang on tight. I'm going to get this camera set up here. It's just hot off the press, so I didn't really even have a chance to get my camera set up. Oh, there we go. All right. Cut on out. All right. All right, so we're back. Okay, so we are talking in this video about strike three. Strike three strikes out. Okay, so what are we talking about here? Now, this is some IP news. If you followed my blogs and podcast videos, you'll know one of the practice areas that we engage in are these torrent downloads, these copying and file sharing of movie files. And I have a case here. If you've been following my videos, you know that what happens usually in these cases is a John Doe is sued in federal court, and they're usually sued as an IP address. So strike three, all they know is an IP address, okay? And here it is right here. You know, you can just see basically, if I put it up there, they're sued as an IP address right there. Do you see that? So that's how they, right here, filed in the Southern District, California. And this over here, you can see what they're looking for right there. This is a order denying an ex parte application for leave to serve a third-party subpoena prior to a Rule 26F conference. Now, if you know what that means, you're probably a lawyer. You're in law school. You're a clerk for a lawyer or whatnot. So, at any rate, what happens is they sue the John Doe, then they go ask the court, please let us serve a subpoena on the ISP. That's who we think the infringer is. So please let us serve the infringer. So that's kind of how these go down. But in this case, and a lot of times these have just been granted. Go ahead. You know, you need to find out who the defendant is. Go ahead. But in this case, in San Diego, Southern District of California, I should say, the judge said no. Judge said, no, I'm not going to let you serve that subpoena on the ISP. It ain't going to happen. And denied the motion, the application for early discovery. And this is the Honorable Barbara L. Major, United States Magistrate Judge. So it's important to know that it looks like this case was heard before a magistrate, which is interesting. But let me just read some of this to you if you've got some time. We got a beautiful view out here out my door. So let's just, let me give you some of the snippets here. So, plaintiff alleges it owns intellectual property and copyrights to the original award-winning adult motion pictures featured on its subscription-based websites. On November 13th, 2018, plaintiff filed a complaint against John Doe, 99.178.13.225. That's the IP address, okay? For 60 alleged infringing movies. 60 alleged. That's a pretty good number. And I guarantee you, whoever was on the other end of this, this would have been a pretty big settlement. So, plaintiff alleges that defendant illegally infringed by downloading and distributing its copyrighted films using the BitTorrent file distribution network over an extended period of time. So plaintiff filed this, and I'm jumping through a little bit here to get through it here for you, but plaintiff filed this instant motion. Plaintiff seeks an order from the court allowing it to serve a subpoena to defendant's ISP, seeking defendant's true name and address. So they want the name and the address from the ISP, okay? And so then the court talks about a big section on legal standard. If you want to go ahead and look that and pause it and get some of the case law, it's up to you. But I'm going to go down to the case that I think was important to the holding here. And this was the Columbia, it looks like insurance company versus See's Candy. Let's just call it the See's Candy case. It's already making me hungry just talking about it. I like that little caramel one or the toffee one. I just love those. Anyway, I don't want to digress too much, but the See's Candy case. And this was the standard that the judge applied in determining whether or not this subpoena should issue. And the court and the judge said here, the district courts in the Ninth Circuit, this was in the Ninth Circuit because it was down in California, apply a three-factor test when considering motions for expedited discovery. This is what they were looking for, expedited discovery to identify certain defendants. First, The plaintiff should identify the missing party with sufficient specificity such that the court can determine that the defendant is a real person or entity who could be sued in federal court. So the plaintiff needs to make that showing, number one. Second, the plaintiff must describe all previous steps taken to locate the elusive defendant. So you have to show some steps that you've taken to try to find the defendant, okay? Three, and I think this was probably the big one, the plaintiff should establish that its lawsuit could withstand a motion to dismiss. So that's your three factors, and that it would be able to withstand a motion to dismiss. Now, one of the grounds, if you watched my other videos, one of the grounds to file a motion to dismiss is the court lacks jurisdiction to hear the case. So I think what this magistrate judge was doing is saying, you know, you need to give me some sort of evidence, something solid beyond mere conclusory allegations, something solid that tells me the defendant is right here in our jurisdiction, such that this court would have jurisdiction over the defendant, such that you would be able to survive a motion to dismiss. And simply put, the court started talking in a little discussion section that some courts have allowed using geolocation technology to trace the IP addresses to a point of origin within the state. So some have allowed just the use of geolocation technology, where an allegation by a plaintiff, hi judge, we're strike three holdings and we're Malibu Media and we use geolocation technology. Some courts have said that's enough. Some have said just IP address. But this court didn't go for those standards. Some cases were cited, but the court did not go with these. Court said, here, plaintiff has failed to identify defendant with sufficient specificity to enable the court to determine whether defendant would be subject to its jurisdiction, okay? So if the court can't determine, the court says, you know, we're not just going to take your word for it, appears to be the position of the court here. And here the court goes on, the plaintiff alleges that it used IP address geolocation technology by MaxMind Inc. This is their company, MaxMind Inc., an industry-leading provider of online frauds, to determine the defendant's IP address traced to a physical address in the district, in the Southern District of California. However, so court talked about that, but then the court's not buying it. However, plaintiff's allegation that defendant's IP address in this district supported by any declaration filed in support of the instant application that would indicate, for example, who used the geolocation technology, the dates of the use, how it is probative of the physical location of the subscriber. So the court wants to know, basically, how does this MaxMind technology work? How do we know it's reliable? How do we know when it was used? How do we know it accurately traces this IP address into the Southern District? So this is some of the problems the court had. Accordingly, no evidentiary support was provided to show that the defendant's IP address likely resolves to a physical address located in this district, and this court cannot rely on plaintiff's unsupported assertions regarding the use and accuracy of the geolocation technology plaintiff contends to have applied. Okay, therefore, the instant application for the subpoena early discovery must fail because there is no reliable evidence to support plaintiff's claim that geolocation technology identified defendant's physical location as being subject to this court's jurisdiction. Okay, so if you followed all that mumbo jumbo, basically the court is in this district here anyway, with this particular magistrate judge. The court denied without prejudice the application, and it is my understanding that strike three then went and dismissed the case. So this goes to show you that not all courts in the United States are buying into this belief that strike three holding or Malibu Media, two of the prolific copyright filers in alleged file sharing cases, they may not take just these conclusory allegations. Trust us, the defendant's here. We use MaxMind, we're good. They're here in the jurisdiction, judge. Give me the subpoena so we can get our money machine rolling here, okay? So this is a really important case, especially if you consider that some, for the meantime anyway, you know, cases can always, I don't know if it was dismissed with prejudice or without prejudice, but for the meantime anyway, some defendant, some lucky defendant somewhere has basically wiggled off the hook, and this was at the court's insistence that there just wasn't enough evidence. So this shows you why these cases need to be closely scrutinized, why our firm is looking at these cases. We're tracking them. We have another big case up in Oregon that we're watching, but it looks like, you know, like I said, we're chipping away here as lawyers representing clients. We're chipping away, trying to basically, you know, be done with this, you know, this prosecution of all these claims. The courts, a lot of courts themselves don't like it. Some courts have referred to these companies as copyright trolls. Some courts have said, you know, we don't like them. They're using the courts as an ATM arm, like an arm in their business machine here. So, but that's a new case that's come on my radar here anyway. And like I said, we'll keep bringing you these cases, but who brings them to you? AttorneySteve.com that brings them to you here. If you like our channel, if you like these legal updates, a little something better than, you know, Russia theories all the time, make sure to subscribe to our channel, and we have some more videos coming for you. I think we're up at about 550 videos now, so we've got a lot of videos out there for you. We got a lot more coming up. If you like this video, punch that like button, say subscribe. If you have any other cases that you would like us to discuss on our legal information channel, just let us know. Put it in the message box down there. And knowledge is power, and we're going to keep fighting till the end on this one, okay? Thanks a lot.